Good morning. I'm Giulia Guagliardi, the chair of the organizing committee of this summer conference. It's a pleasure to have you here in Rome, and I thank you all for coming. It has been a very long journey since June 2018 when we candidated Rome as hosting city, and I still remember the enthusiasm of all the people in Amsterdam when we raised up our hands saying Rome. But I do remember that after a few minutes, I looked at my colleagues and we thought, what are we going to do right now? Because that was our first EYBA event, so we basically didn't know how it was and how to organize it. And that's why I would like to thank the members of the organizing committee in Amsterdam and in Moldova for having shown us how to organize a successful event. Because it hasn't always been easy, to make a puzzle from all the pieces. And with pieces, I mean ideas that needed to become concrete. And that's why I would like to thank the members of this organizing committee for having dedicated themselves to this project and for having been enthusiastic. Because I think that nothing great was ever achieved without enthusiasm. And so I really would like to thank them for being enthusiastic. I think that this can be the key word of this summer conference, of course, together with pasta, wine, pizza, and so on. But above all, I think that we are going against stereotypes, because when I travel abroad, it happens quite often that people say to me, Giulia, you can speak English quite well. And they are surprised, I think that because I'm Italian. And maybe they are right, maybe there are a lot of Italians that do not travel that much. Maybe there are a lot of lawyers that do not feel the need to meet lawyers from other countries. But not today, not here. We are demonstrating that stereotypes have their own exceptions. And I'm very happy to say that we have representatives from more than 20 countries in Europe, but also from Russia, Canada, and United States of America. And I think that we keep on following a new trend for this city, which in 2018 and 2019 is hosting so many international conferences related to legal issues. And in this regard, I would like to thank a lot the Council of the Rome Bar Association, and I mean all the Roman lawyers, because the Council is giving great opportunities to young lawyers selected each year among several candidates, entrusted with the organization of seminars, conferences, but mainly to travel abroad and build international relationships with local and international association. So basically, without the support of the Council, this event wouldn't be possible. And I don't want to steal more time. We have a full agenda. I would like to thank all the speakers that are going to speak today, which are also representatives of sponsors of this event. So without them, this event, again, wouldn't be possible. So now I would like to give the floor to the other speakers for these welcome remarks, and in particular to Andrea Pontecorvo, which is a member of the Council of the Rome Bar Association. And again, I thank you all for coming, and I hope you will enjoy it.
Ovviamente i miei saluti sono in lingua inglese, scusatemi per la non eccezionale pronuncia e quant'altro. Dear colleagues, on behalf of the President of the Bar Association, Mr. Antonino Galletti, the entire Council and especially on mine, our warm welcomes to Rome to you all. A special greeting to European Young Bar Association, which has intended to entrench in our territory the important and formative passing of Summer Conference 2019. I would also like to welcome to our financial responsible, Mr. Alessandro Graziani, in the council in our council, and to Grazia Maria Gentile, who is responsible with Cristina Tamburro of our activities. For all of us lawyers in the Italian capital city, this is a great honor and pleasure. The attention that the Roman order pays to the treatment of young members is confirmed by the constant research of the best solutions, facilities and privileges that the Council provides and promotes. And this is made possible through its committees set up under Article 32 of professional law, notably the Young People Commission in addition to consular sectors. One of the latter, from over 15 years, gratifies, according through their preparation, it is possible to spread, for instance, the new technologies. All seminars, the courses and meetings tailored to the examination and the study of the new norms are headed by them and to them. We attend from the new lawyer's new lifeblood, rooted in its own energy, in the great Italian and Roman forensic tradition, be inspired by it, but also adjust to the current reality in order to build a brighter future, radiant like the one that, we are sure about it, will outcome of this event. I would have much else to say, but I don't want to take any more of your valuable time away from your job. But be sure about one thing. You will be involved soon in the numerous projects that we already have been pursuing for a long time, and with you all, we are going to put into practice in favor of advocacy. Long live to the young lawyers, long live to the European Young Bar Association.
So now I would like to give the floor to Alberto Vermiglio, which is the President of the Italian Association of Young Lawyers, National Section.
Buongiorno. Lo farei volentieri in italiano, ma lo farò in inglese. I apologize for my English. Dear colleagues, I extend to all of you the greeting of the Italian Young Lawyers Association and my personal one, and I am honored to be here with you to take part in the EYBA Summer Conference. We are guests of the Palazzaccio, which is the highest court where a lawyer can express his oratory and professionalism. By creating occasions like this, where young colleagues can share different cultures, different regulations, and the professional experience, we guarantee the personal growth that characterizes every association activity. I am sure it will be a very interesting conference, and I am also sure that we will be able to enjoy the splendid hospitality guaranteed by the organizing committee and by our wonderful Rome. I wish you good work.
So now, last but not least, I give the floor to Guillaume, the President of the European Young Bar Association.
Okay. Morning, everyone. So, I'm very pleased to be here today for the opening of the summer conference of the European Young Bar Association. I feel honored to be invited in this amazing place to deliver these warm words of welcome. I'm glad to be here in Rome for my first time in Italy, and I'd like to take a moment to thank the bar and the Young Bar of Rome to organize this truly international event. I also want to thank the speaker who will generously share their experience and knowledge during this day. Many of you are already familiar with EYBA, but I would like to highlight one of the important aspects of the EYBA: the ability to grow up and develop networks, but also the opportunity to make new colleagues and find new friends. In my point of view, it's the best way to share experiences, culture together. So, I'm very excited to tell you that EYBA is one of the most representative associations of young lawyers in Europe. To tell you that EYBA is recognized by the Council of Europe as a participant to the ENGO working sessions. To tell you that EYBA organizes 3 conferences per year everywhere in Europe. And to tell you that the EYBA Summer Conference here in Roma hosts so many different countries. Today, Rome is the European capital of young lawyers. But as I said, being members of EYBA is above all a fantastic human adventure. I believe in this adventure, which represents a balance between opportunity, networks, and friendships. So, when in Rome, I think it's now with all of you. Thank you for listening and enjoy this conference.
Now we will start with the conference. I would like to introduce you the moderators for this conference, Guido Befani and Barbara Piro. They are both members of the organizing committee and representative of sponsors and partners of this event. Barbara, she's a member of the Rome Young Bar Association, while Guido was a member and now is a member of the executive committee of the Italian Association of Young Lawyers Rome section. So thank you again, and I hope you will enjoy it.
Thank you, Giulia, for your presentation. Good morning, everybody. My name is Barbara Piro, and I am the first secretary of the Roman Conference of Young Lawyers. Before we get started with our presentations, I just wanted to remind our speakers to please respect the tight schedule that we have today. So you have 20 minutes for your intervention, and at the end of it, there will be time for some questions. Please welcome our first speaker, who is Mr. Luca Pardo. Luca Pardo is founding partner at Pardo Vicenzi, which is one of the law firms sponsoring this wonderful event. His practice focuses mainly on corporate law, commercial law, European Union law, and intellectual and industrial property law. Mr. Pardo also assists many companies in the process of internationalization, and in his lecture today, he will explain us what does it mean to be a global lawyer. Thank you.
Thank you. Dear all, welcome to the EYBA Summer Conference 2019. I wish to thank EYBA for making this conference happen. All the colleagues that have worked hard to build up these events, and everyone for being here. I'm Luca Pardo, and with my friend and partner Valerio Vicenzi and with Ontier, we founded Pardo Vicenzi. Ontier is a global law firm with 21 offices in 14 countries. I will try to answer this question. What does it mean to be a global lawyer? This is not a question. This is a challenge. The real challenge for all of us lawyers. Let's start from Rome, the city that is hosting us, because Rome has been the first global empire and is proof of what it means to have been global. Roman Empire founded its strength on conquering other peoples. I will not talk about the war aspects because they are not relevant to our purposes and because they are common to all people of that time. But most of all, and this is what really matters today, on the ability to promote interchange from local cultures. We can think of the Etruscan, the Greeks, the Carthaginians, and to interact with other populations, language, arts, goods, traditions, coin and law, demonstrating a great capacity of cultural assimilation. Roman Empire became a real global market where goods, ideas, and people circulated freely, and each region contributed with its products and its men to this interchange. Romans were able to see the best in other cultures, often adapting their ideas and lifestyles to external models. We think Greek philosophy, Greek lifestyles, arts. But when Rome started considering itself as the center of the world, and this capacity to assimilate, to be dynamic, to be global, came to an end, then the Roman Empire came to its end too. Let's take a leap 2,000 years forward. The latest generation of communication tools is characterized by a revolutionary innovation with respect to any other means of communication that preceded it: interactivity. Many believe this is the most important communication revolution since the invention of printing. This is the digital revolution. We therefore have more and more tools available that allow us to be constantly connected to each other in the world. Furthermore, these tools make us light, fast, nomadic, like the data we transmit. These instruments are like the river Tevere, Mediterranean Sea, and coins to the Romans. They take us through the world. By comparison, the true reality is a slow and cumbersome place, and we are as heavy as pachyderms. To better understand what I just said, let's make an example. The following pictures show a transformation. Table football belongs to the mechanics of things. The shots are real, the ball is real, we are actually moving, our muscle react. With Commodore 64, the experience changes completely, and it becomes a man-button screen equation. This man-button screen equation will be the posture, our posture, of the digital age. In Commodore 64, everything is immaterial. The sounds are not real, and neither is the ball or the protagonist of the game. The gesture is light. There are many game solutions. You just need to change the floppy disk. To play together, two or more friends must meet, be next to each other in the same physical place, each one with a joystick. With PlayStation, you don't even need to be in the same physical place to play together. You are part of a non-physical group of players. You don't need to meet others, but simply share the same rules of the game you want to play. A group where nobody is the center. These small examples lead us to a conclusion. The digital revolution with the web, the internet, Napster, Facebook, Instagram, and so on, has devastated many of our mental blocks. It has changed the format of the world. It has freed us from the obsession of borders and division lines that were typical of the last century. It has offered us the global profile of the world. Everything we have just said has a lot to do with us as global lawyers. Globalization, together with economic crisis as a trigger, have led companies to expand their horizons and go out to foreign markets. And on many occasions, this process of internationalization of companies has been carried out by law firms and lawyers that have handled this not so easy challenge, which involves advising clients in different jurisdictions. As a result, law firms have been called to internationalize, whether establishing offices abroad, or merging or affiliating with foreign firms, or create new formulas to advise their clients in their multinational transactions. In other words, the clients becoming increasingly global require global professionals and innovative solutions. The tools at our disposal have a clear technical characteristic. They are global instruments. They erase boundaries and distances. But having tools that show us the way of globality is not enough if this is not followed by a subsequent and mandatory step, being global professionals ourselves, assuming global awareness ourselves. What I just said is intuitively simple, but incredibly complicated to implement, especially for us lawyers who operate in an area that is still tightened by the narrow local regulatory and applicative boundaries, although this area is increasingly affected by supranational problems, which require innovative organization, solutions, and a new agility in teamwork. I myself have tried to answer the question, what does it mean to be global? And what I managed to put together are these suggestions, but they certainly seem to me only a good starting point to share with you. First, never think of yourself at the center. Nobody should consider himself, herself, as the center to which others must tend. Nobody should wait for opportunities to fall on the table. We must convince ourselves to be, depending on the case, starting points, connecting points, or arrival points of a job, a project, an operation. Our work consists not only in researching and assisting local or foreign clients who intend to operate in our country. This is an old-fashioned vision of international law. But in helping clients that want to start projects in countries far from ours, and therefore be co-protagonists of their project. Let's also consider that on the one hand, the law is progressively detaching from national borders to access a further dimension that goes beyond international law, more properly global. On the other hand, state systems are becoming open to the influences of other states or supranational systems. Second, understand and absorb diversity. We must take advantage of what others do better than us because of their culture, their professional training, their attitude, and absorb this value within our culture, our way of working, so to give birth to a common denominator of tools and ways of being that identify a global lawyer. We must learn from who is better than us under several profiles: innovativeness, human profiles, way of working. Third, change and provide global answers. While facing supranational issues, we must change the way we work, the way we offer solutions. If we take advantage of the connectivity offered by the tools of the digital revolution, we will be nimble our way of working. The global lawyer must be able to manage multicultural teams, to manage the differences between people in this new scenario without borders, both internally in his law firm, in his offices, and externally, in order to know how to properly manage an international client or simply a foreign client. Let's think to build up, for example, global teams of lawyers to handle global matters. For example, GDPR, intellectual property, energy, compliance. When we will present to a client such a solution, a global team, we will be surely identified as different from the others. Fourth, use technology. As said, we are in the middle of the digital revolution. The global lawyer will be a technological lawyer, fully used to digital tools and able to resolve problems remotely and in real time. Think, for example, of blockchain and smart contracts, where an excellent lawyer is needed but not sufficient. Technical skills are essential. Moreover, the global lawyer will be able to work efficiently everywhere, will always be connected, and will have access to his files and work sources wherever he is. Fifth, finally, move. We cannot say we are global lawyers if we do not accept the challenge of stepping out from our local borders, even nullifying them, and from our comfort zone. To know the world must be considered part of our job the same way knowing law is. Last year, this is just an example, we organized in our Italian office a course in geopolitics with a professor who explained to us where the world is going, the big problems, the challenges, and how to understand our time. This is, I believe, the necessary starting point. Moving is therefore the antidote to stop considering ourselves the center of everything. Is this the occasion to learn from others, to assimilate the best from others? It is of paramount importance to give ourselves every day new eyes and every day be one step ahead. Thank you.
A special thanks to Mrs. Lucarpardo for this speech, very interesting, and for this deep analysis on this topic that is very effective for our profession as a lawyer and modern lawyers, of course. There is any question, or there are any questions for Mrs. Pardo from the public, or you want to? So.
Yes, I would like to ask. I would like to ask this question, which is actually a provocative question. What would you say if someone told you there will be no world for lawyers?
Yes, there is. Definitely. Why? Why not?
I'm asking. In the future.
Yes.
Be careful what you're answering.
Yeah.
In the future, some people tend to say there will be no world for lawyers, there are too many lawyers.
Yes.
What would it be of lawyers tomorrow or in 10 years?
I think we are facing I think you refer to many lawyers and facing a digital revolution where digital tools will try to replace lawyers in artificial intelligence and so on. But what will be not substituted by anyone is the human attitude of a lawyer to face the problem with the client. In Spain, I saw a magnificent message that was a man under the rain, and the message was "Nos mojamos contigo." We are with you in every occasion. The capacity of facing complicate issues and to give the added value of a lawyer, as a person, as a man, with the attitude to handle the case of the client, will not be replaced by anyone and anything in the future. So, a word for lawyer is the future. The challenge is to understand what is the right place for us as global lawyers, as young lawyers, and so on. But me not so young, but to detect the opportunity and to give to the client our special attitude, that is to understand the moment, to understand the issue, to understand the problems, and be aside and along the client in his work.
Thank you.
Thank you again, Mr. Pardo, also for your answer to this very provocative question of my colleague and friend, Barbara. Now, I have the real pleasure to introduce Miss Raffaella Betty Beruto, that is the partner of probably one of the most important and prestigious law firm in Italy, that is Gianni Rigoni Grippo Campelli and Partners. And she is an expert of employment law and industrial relation and of the transfer or undertakings. In her speech of today, she will talk about this very actual problem in the economic context and actual international relation. I introduce also our member of the Italian committee, that is Mrs. Chiara Palombi. She is member also of the Italian Young Barrister Association, and she helped us in this part of the organization. Thank you.
Good morning. Thank you, first of all, for inviting me to this really outstanding panel. I'm in a throne, so very comfortable. So today we're going to talk about gig economy and decent work. And I will give a just brief overview about how this topic has been dealt with in various countries all around Europe, whereas Chiara will give a brief outline about how this has been dealt with the court cases in point in Italy. But we all know how technological innovation has really had a very big impact and has drastically changed all the working conditions, employment, industrial relations, and the gig economy really had led to a proliferation of very numerous atypical formal employments. And therefore, today is really the big challenge today is how to ensure decent working conditions for this category of workers that is increasing, although it's still representing really a very minority of the total workforce. We're talking about 1%. However, there is an increasing trend. And for some commentators, they're going to replace maybe the traditional workers. I hope in a very long, distant future, but in any event, we have to face these issues today. And I think the challenge in really trying to understand what is the best regulatory framework to be applied to this category of workers is a big challenge, because first of all, how can we really harmonize and get to very uniformed regulatory systems for these workers who are characterized by diversity? They have different needs, and actually they have different employers, they work for different platforms at the same time. They are sometimes geographically located, if we think about app-based workers, but at the same time we have some workers that are not even geographically located. If you think about crowd working, for instance. And also we have undisclosed workers. They're really invisible. They are not, and even those who have a contract may not be registered with the social security system. And this has made really difficult to conduct surveys about how to get statistic data. It's really a big challenge. So it's very difficult to have an accurate picture of who they are, what they want, how they are organized. And we know how it's really important to get this statistic data, because if we don't have a background about these workers, how can we come up with the right solutions? Also a big challenge because they are not physically in one place, and so they are so dispersed. Sometimes they competing one against the other. It's really difficult then to get them organized, to give them a collective voice. And all these topics have been addressed in various countries in the different manners. We have 3 different approaches: negotiation, legislation approach, and then court cases that I will leave to Chiara. I will focus on the first 2, anyway, this negotiation and legislative approach. But negotiation is so relevant. It's undoubtful that, of course, trade unions play a very crucial role. Thanks to trade unions, we have had an increase of the working conditions, and really through trade unions, workers has always had a collective voice. But for the reasons that I mentioned earlier, it's very difficult to give collective voice to this kind of category of workers. Also consider that one of the other really big problem is that most of them are self-employed. And in certain jurisdictions, self-employed are not entitled to join trade unions because of national competition laws. But in any event, we see developments in the European court cases, because now there is a tendency to recognize the right for self-employed to join trade unions and to have a collective actions by considering whenever the self-employed can be assimilated to employees. Having said that, if we want to really think about where we have in Europe, for instance, the strongest collective bargaining negotiations, here we have to make reference to the countries of north of Europe, such as Sweden, Norway, for instance, Denmark. They've always had a long history of a collective bargaining agreement, and now we see a very good example of collective bargaining agreement for the platform workers, either as employees, such as in the case of Sweden. I think, yeah, Sweden, because there is, thank you. In Sweden, we have these taxi drivers platforms who are then hired as marginal part-time employees and are covered by collective bargaining agreement, for instance. Then we have also certain cases of collective bargaining agreement regarding self-employed. That is very interesting in Denmark, where there is this cleaning service platform company that has reached an agreement with the trade unions, according to which the self-employed are given the possibility to, once they have worked 100 hours, given the possibility to shift to the status of employee. And this is an option given to these workers that is very peculiar. I've never seen a collective agreement giving options to someone to shift from independent contractor to a status of employee. So they have these minimum protection as a self-employed, and then they get a higher protection once they decide to shift to the status of employee. We have also an interesting experience going on in Norway, where Foodora is negotiating a collective bargaining agreement for the food riders. And it's interesting because Foodora has recognized the status of employees to these workers. And also considering that it's a German multinational, so it's actually now negotiating in a country like in Norway, so not in Germany, and it's negotiating an agreement, whereas in other countries Foodora does not apply collective agreement. Then we have the cases also of Austria, where Foodora has recognized to its riders, employees, the right to elect works council in order to give information and co-determination right. And also interesting to note that always in these northern European countries, platform companies are given the possibility to be registered as a temporary work agency, so that the workers then are covered by the national laws regarding temporary agency work or the collective bargaining agreement regarding temporary work agencies. Then the other approach that I mentioned is the legislative approach. Here there is an example in France of Loi du Travail of 2016, given the right to self-employed to take collective actions without the need of involving trade unions, and similar rights are given to platform workers and who are in any event entitled to join trade unions. Now, focusing on Italy. So here in Italy we have all these three approaches: negotiation, legislative, and court cases. As regards negotiations, it's interesting to note that we have, as we all know, we have a very long and solid history of industrial relations. However, I think that trade unions have not been, at least at the beginning, really very active, as much as we have seen in the North Country. They've been more active in supporting the court cases in point and in also conducting information like campaigns in order to raise the level of awareness of the food riders about their rights. I'm talking about food riders because in Italy the food delivery company is actually very strong, and that's why we have court cases addressing always food riders. And we don't have Uber, it's forbidden. Therefore, here when I talk about the Italian platform workers, I will mainly refer to food riders for this reason. So here in Italy, the trade unions, as I said, have not been so active as we would have expected. However, we have example, of course, of social dialogue, because they signed a so-called paper, Fundamental Rights for Platform Workers in Bologna, in the presence of a mayor of Bologna, trade unions, and also companies of the food delivery business. However, this declaration has not been signed by the major food delivery companies such as Foodora, Glovo, etc. So it's a limited application. Then we have also the example of a national collective bargaining agreement of the logistics sector that is has dedicated a section to the riders working through online platforms. So under this agreement, obviously, the riders have been given classifications rights, minimum compensations, and social security insurance coverage, and so forth. However, this collective agreement has had limited application because it regards a certain industry sector and also applies as long as the company has decides to adhere to the same. But we expect that this agreement will have actually much more broader applications because in light of the very recent court decisions that has been rendered in 2019 in relation to a food rider of Foodora. In this case, the Court of Appeal of Turin has confirmed the status of self-employed of the food rider who brought this misclassifications action, but at the same time has recognized certain employment rights, and then by also specifying that the riders is not going to be entitled to the full employment legislation, but only to certain minimum economic rights. So we talk about minimum pay, overtime, and then vacations, social security, insurance coverage, and in order to determine these minimum rights, the court has made reference as a benchmark to the collective bargaining agreement of the logistics sector. And by doing so, the court has in certain way emphasized the role of the trade unions in determining the minimum protections for the platform workers. Just also to recap, here in Italy, riders are mainly engaged as self-employed, and we have in a different ways. So occasional consultants or continuous collaborators or VAT freelance, and all these distinctions also depends upon the level of income of these self-employed individuals. And they have also different protections depending upon their classifications. The continuous collaborators, for instance, have the strongest protection because they are entitled to be registered with Social Security, they have an insurance coverage, and whereas the occasional consultant, these are those whose income does not exceed 5,000 euro per year, then these category of workers, for instance, are not registered with the Social Security, and therefore they don't have protections. So you see how, we have really a diversity here in Italy as to the terms of engagement and protections given to these category of workers. So having said that, now if we think about this experience that we have in Italy, we have certainty we are moving forwards in order to afford these protections. But it's very significant what's going on at the governmental level. Here, I don't know how much time left. Okay, okay. So here at the governmental level, must make like a little bit of introduction. Here in Italy, our government actually is represented by coalition. So we have the 5-star movements and the Northern League. And one of the main point of the political agenda of the 5-star movement was really the recognition of employment rights to food riders. And for this reason, the Ministry of Labor, Di Maio, that represent the 5-star movements, initially has opened a table of discussions involving all the social parties engaged in the platform industry in order to try to reach an agreement in this respect. But this table failed. But not only that, before this table failed, a law at regional level has been enacted by the president of the Lazio region, providing for minimum protections for the platform workers. And the president of Lazio region actually is a leader of the PD movement that is at the opposition. So it's competing against the 5-star movement, and it's clearly this action is all has a political reasons in order to show that, of course, they are doing better than the 5-star movements. So if we look at then, because of this competition between the two, then we have on one hand this regional law that is actually, to my view, very anachronistic approach to try to really face this issue at the regional level, so that we would end up having different regulations that may diversify region by region. But also the content of the law is highly criticized because by recognizing minimum rights such as information, transparency about how the algorithm works, then also provides for other minimum compensation, that it must be based on a hourly rate and cannot be linked upon like delivery. It's been highly criticized. Also because it might be considered unconstitutional, because these issues concerning the compensation upon result, this kind of change in law cannot be regulated at regional level, but rather on a national level. But at the same time, the enactment of this regional law has accelerated the process of enactment of this bill of law pending at national level regarding the minimum rights concerning the platform workers, according to which the minimum protections and references made to employment rights must be given to those continuous collaborators whose modalities of exercising of the services are organized by the principle also through platforms. And by doing so, has been also the question actually is when we talk about employment rights according to this bill of law, are we referring to the employment rights as defined and determined by the very recent court's decisions in rendering 2019, referring to the minimum economic rights, or rather to a broader employment rights? And this is really the big issues, because we don't want to end up recognizing the stronger protections, very strong protections that are afforded to employees in Italy, especially with regard to the unfair dismissal rules. Also, another question that I want to end up my intervention by also just raising these remark is really the governmental approach, the right way to answer to this issue. Meaning that imposing by the government, imposing minimum protections when sometimes government may have a partial view about the industry. Would it be better to leave this matter to be dealt with through the social dialogue, because therefore, through the intervention of the trade unions, that seems to be also the approach as suggested by the most recent court's decision, that by making reference to this collective bargaining agreement of the logistics sector for determination of these minimum economic rights, has emphasized the role of the trade unions in determining the protections with regard to the platform workers. Now we'll leave Chiara to comment on the court cases.
Thank you very much, Mrs. Betty Beruto. Now is the time for Chiara Palombi. His intervention will focus about some legal cases and other specific decision of the tribunal about this topic. Please.
Thank you. Good morning, everyone. Thank you, Raffaella, for this very complete introduction on the phenomenon. And, well, as Raffaella said, it is very important also to analyze the case law approach on this very specific matter. So I will try to focus my speech on the case law, the Italian case law, and if I have time also on the European case law, to see that judges are not unanimous on this very specific subject. But let's analyze the circumstances related to the rider's case dealt by the Italian courts, and in particular I will analyze the first three judgments in Italy about these subjects, that are the judgments of the Court of Milan, of the Court of Turin, and the Court of Appeal of Turin, which is slightly different from the first ones. Well, let's focus on the circumstances, because it's very important to understand which were the circumstances, to understand why judges have taken their final decision on the about the qualification of the riders, employees or self-employed. Let's see the circumstances. Well, these riders had contract, self-employed contract, in specific short-term contracts of coordinated and continuative collaboration with the company, and or contracts of occasional work. So self-employed contracts, it means that they don't have recognized certain rights that instead employees have. The riders has to be recognized as employees, of course, and their job consisted in deliveries, as you probably know, of ready meals ordered by means of a smartphone application created by the company. Their remuneration was about €5 or €7, it depends on the company. And, one condition to be hired was to have bicycle and have a smartphone, of course. And instead, on the other side, the company supplied riders with helmet, t-shirt, jacket, bicycle lights, and a box to carry the food, of course. Well, what these two words mean, slots and swaps? Well, the point is that the riders were free to book their own shift that are called slot in this field. And then they were also free to change their shift whenever they wanted, whenever they prefer. And what it is particular is that these riders could also decide to not show up at work, but we have to see which were the consequences of not show up or swap their slot. Well, a consequence of not showing up at work could be a negative rating, and this had another consequence, which is have less opportunity to choose the slot, or maybe not to be called again by the company. In fact, it's important to note that in the case held by the Court of Milan, the rider was not called anymore after he got injured at work and after being absent for 2 months. Well, it's interesting also to see which is a typical day of a rider, and so the judges also took in consideration this. A day of work was consisted in go, reach the meeting point, then turn up, of course, turn on the app on the smartphone, then receive the order. Then, once that they have received the order, they were supposed to reach the restaurant, also choosing the path they prefer. Then they were supposed to take the food order, control that the food was exactly the food order. Then they have, of course, to reach the customer's address to deliver the food. Well, the point is that the riders were supposed to deliver the food in about 30 minutes, otherwise they could receive a sanction of €15. But they say they were free because they could choose the path they want, so it was their own responsibility. Well, let's see how the court decided in light of the facts that I showed you. The judges decided that the riders could not be deemed as employees, but they were just self-employed because of 2 main reasons. Because according to the judges, there was absence of the employer's power to give directives and to organize the work, and in addition, the absence of the power to give disciplinary sanction, which, as you probably know, are the 2 key elements to consider an employment relationship as a subordinate employment relationship. But as Raffaella before mentioned, these judgments were slightly changed from the Court of Appeal of Turin, because of course the riders were not satisfied with the very first decision of the Tribunal of Turin. And well, it's interesting to note that the Court of Appeal found a third way, let's say, because the Court of Appeal decided that they could be classified as a third gender of worker, let's say. And the Court of Appeal could do that by applying the Article 2 of the Legislative Decree 81 of 2015. Which set forth a particular rules according to which a worker can have recognized certain rights of the employees, even though his or her contract is a self-employed contract. And the condition to apply this particular statutory provision is that their activity have to be strictly personal, and their activity has to be carried out in a continuative way. And the last condition is that the company has to handle the organization of the work, but just with particular reference to the time and the place of the work. But this decision of the Court of Appeal of Turin has been a bit criticized by scholars because, yes, it recognizes some rights to these riders in spite of being self-employed. But the point is that this particular Article 2, that I mentioned before, does not specify which rights exactly are recognized to these riders. For example, it is not recognized the right against an unfair dismissal. So it is not clear if it's recognized, I don't know, minimum wage, social contribution, which one exactly are the rights that these riders are entitled to. Okay, actually, my overview on the Italian case law basically ended, and the approaches in other countries, I left you, I will leave you for some question if you want.
Thank you very much, Chiara, for your presentation and your speech. There is any question about this topic from the public? I guess no, from the...
If asked who is paid for, sorry, could you repeat? Yeah, in fact, this is the problem. This is the reason for which they are asking to be qualified as employees and not are self-employed, because the problem is if they are self-employed, basically with some kind of contracts, they don't anybody pay for their injuries. So if instead the employer pay, of course, the social security contributions and pay for them, in that case they would pay. So yeah, you're right, the Court of Appeal try to find a solution for this very specific problem, and I think that analyzing the Article 2, maybe we can in this way consider that the riders can be paid if they are injured, if they are considered self-employed, but with the recognition of certain rights typical of employees.
Also remember that here in Italy we have this peculiar situation of the self-employed, even before the Court of Appeal, that when I mentioned the continuous collaborator, these are by law registered with the Italian Social Security Agency, and by law they are covered by insurance coverage. And it was very interesting to know that according to certain statistics and surveys, that there was like really significant number of riders qualified as a co-co-co, and who were not aware of these kind of rights. So that's why it's been very important to raise the level of awareness of the riders about their rights, and that's why the trade unions also focus on conducting this information campaign. That's no, for the civil. That's up to the company. Sometimes we had cases where they decided to recognize the civil liability, for instance, but it's up to the company. But when the court cases address this sort of matters, that they always refer to Social Security and mandatory insurance coverage. So covering accidents against like risk against accidents at work.
So, thank you both for your position. There is any other question about the desk? No, I hope no. Okay, so it's my pleasure to announce a short coffee break. The buffet is open and we have more or less 20 minutes, okay? So, thank you very much all. Let's start the second part. I leave you the word to my colleague Barbara Piro. Silent, please.
Thank you, Guido. Our next speaker today is Professor Alessandra Levy. Alessandra Levy is partner at the law firm Coccia De Angelis Vecchio e Associati, which is one of the law firms sponsoring this event today. She works in the field of civil and commercial law, and she teaches courses and LLM courses which take place at Sapienza, University of Rome. She's also the director of studies of the LLM in private European law, held also at La Sapienza University. In her lecture today, she will deal with the discipline of international and internal trust. In Italy, the debate on this subject has recently focused on the so-called internal trusts. And only recently, those trusts have been admitted in the Italian legal system. So, now I leave the floor to Professor Levy. Thank you.
Good morning. Good morning to all. Okay, I am pleased to be here on this occasion for a number of reasons, some of personal nature and are more properly legal. First of one, I would like to thank Maria Chiara Pollicino, who invited me here. He is a talented associate lawyer in our firm, and very young, but very talented. And this is the first reason I accepted to come here, of course. And I'm, in any case, very honored to participate in this event, since your association of young lawyers makes me go back to the past, when during the summer of 1990, I took a part in a course of American International Law, American Civil International Law in the United States. This course was attended by 80 lawyers, and on that occasion, an Australian lawyer, a colleague, asked me about the legislation of the trust in the Italian legal system. That was the very first time I began thinking about the trust. I was just graduated, and in legal book, Italian civil law book, the topic of trust was really few mentioned, very briefly. Later on, I found myself dealing with this instrument in my career as a lawyer. Perhaps remembering that episode, I decided to come here to talk about this instrument, the trust. But I can imagine that all of you knows what is trust. In any case, we need to have a general definition. Generally speaking, trust is settled by a person, the settlor, through a declaration of will, and this declaration, it can be effective inter vivos or mortis causa, and the person who places some of the assets under the control of the trustee for the benefit of a beneficiary or for a specific purpose. That creates a legal relationship between settlor, trustee, and the beneficiaries. And the consequence of the institution of a trust is that the asset constitute a separate fund and are not a part of the trustee's own estate. Moreover, the title to the trust asset stand in the name of the trustee or in the name of another person on behalf of the trustee. The trustee has the power and the duty in respect of which he is accountable to manage, employ, or dispose of the asset in accordance with the terms of the settlement of the trust. This is the general frame of trust, the general meaning of the trust. But now, and it is now, I'm going to explain the reason why it's necessary, it's useful to talk about trust. Because this instrument, this tool, is increasingly used by natural persons to manage their interests at the present. And still, it is a very complex topic in our legal system for a fundamental reason. It's clear that I'm speaking from the perspective of the Italian civil legal system. From our point of view, the fundamental reason why this topic is still complex is that within the Italian legal system there is currently no comprehensive and systemic legislation on trust. Till now, we don't have a legislation on trust. So, the role of a consultant, I like lawyers and also public notary. In our system, we have a public notary. Is very important because it's crucial. Their role for individuals, they have to understand what are the needs, the interests of persons, and translate it, knowing also the legislation of the states in which the trust, by which the trust will be regulated. So it's a problem. It's a big responsibility for the consultant, because the consultant, the Italian consultant, has to know the law applicable to trust, that will be applied to trust. It's moreover, trust, it's an interesting subject for more general reason, because in this, with this issue, you have to deal with different legal sources. I mean, you have trust state law, convention, our Italian law, because in case of public order, there are some limit to the application of a trust law, foreigner trust law, and also you have the private interest expressed in the settlement of the trust. So you have to deal with all these different legal sources. And then, as we will see later, it's very important for the evolution of the institution, the interpretation of the law, and so the role of the doctrine and of jurisprudence. So trust is an interesting instrument, not only because it is an important instrument for persons to deal with their interests, but also because it is a kind of situation that can be used as a mirror through which we can see so many problems of our legal system after globalization, okay? So, but in any case, we have to talk about trust. we have we have to start from the Convention on Trust. As I said, there is no law, Italian law on trust, but Italy signed a convention, which is the Hague Convention of July 1985, which is a convention on the law applicable to trust and on their recognitions. And after the signature of this convention, this convention has been ratified by Italy. We have listed, and you can see in the slide, all the states participating to this treaty, okay? But the fundamental distinction is that there are inside that list states which belong to common law system state and other which are civil law system. You know, Italy belongs to civil law system. So before 4 states belonging to civil law system, trust before the convention was unknown and thus was not recognizable in Italy as for a series of reasons that I'm going to explain later. Because this creates a kind of different category of property. And also this instrument is going to create a separate fund. And we have some principle in our system which are in conflict with this type of instrument. But really this was the situation before the convention. But we have to try to understand what was the role of the convention in this situation. I put on the slide declaration of 2 lawyers, Dutch lawyers, who summarized some of the difficulties of non-trust states in a preliminary report before the signature of the convention. And this is the phrase: can the trust, this corpus alienum, be recognized at all? And if so, under what category or categories of law should the trust or different legal relationship it creates be arranged? Under the law of succession, the law of contract, the law of property? And if this problem of characterization or classification has been solved and the applicable law has been determined, further question of the adaptation or conversion into civil law institution may have to be faced. The result is that when it comes to litigation, the outcome may be highly unpredictable, as the parties and the courts will frequently be in the dark as to the way the trust should be handled. So it was a declaration made by lawyers belonging to a civil law system, and we can see from this declaration the problem with regard the trust before the convention. So why signing the convention? Because in any case, the following cases could happen in the past, and of course still happen today. Trust assets are located in a civil law state. Trustees are domiciliated in a civil law state, beneficiary are domiciliated in a civil law state. And this is, of course, not so strange to happen, because if you consider the Treaty of Rome of 1957, the purpose of the treaty was that to promote the free movement of persons, services, and capital. And so it is normal that the situation we described could happen, so that trust has connection with the different legal system. And we call this international trust. But before, as I told, before the convention, sometimes civil law judge refused to enforce the foreign judgment, saying that it infringed public policy of the non-trust state. Sometimes, trying to establish the applicable law, the civil law judge used civil law categories, distorting the rights, powers, and obligations that were and are inherent in the trust relationship. So, as you can imagine, before the convention, as I pointed out in the following slide, our judge refused to admit trust in our legal system. As I told before, trust created some problem in the civil law state as follows. Because the treatment of the trust asset is separate from the trust's personal wealth. The division between legal and equitable ownership, which is a concept of English law, such as joint tenancy and the right of survivorship, were largely meaningless. We don't know, in our system, we don't have a division in property. We have just the property as on one whole. And also we have the principle that rights in rem forum form a numero chiuso, numerus clausus, and so the rights in rem are just those contemplated in our Italian civil code. And also the possibility to create a separate fund immune from the claims of one's creditor, it's not admitted. It was not admitted because we have to see that our system has been changed since the approval since the ratification of the convention. So, as you see, we have mentioned just two tribunals, one of 1956 and the other of 1984. It means 1 year before the ratification of the convention. The position was almost the same, the refusal of trust in our legal state. And this creates, as you can understand, a serious problem, because in any case it happens so much with a certain frequency that there are international trust. I mean trust related to different system, and in some cases to system that belongs to civil law system. So that is the reason why it was necessary to sign to reach an agreement between the state belonging to civil law system and state belonging to common law system to find a solution to this situation. So, why creating a trust? Trust, it's not only important to have to be introduced because of this international aspect of our life, but also because it's going to protect private interest, which can be to be evaluated. So, what are these interests? Using the words of the preamble of the Convention, trust is a unique legal institution. But why unique? Because trust is a flexible tool, and it can be used to fulfill several needs. In the family context, it represents a safeguard for the integrity and destination of assets, also a safeguard for the vulnerable components of the family, also a possible settlement to difficult family situation. In inheritance, it is used the charitable trust. It's an instrument whereby the assets are devolved to a charity institution to a certain date. Or it can be used also in the corporate context. A trust can be created to better enforce the shareholders' agreement, or a trust can be used to grant a corporate bond debt as an alternative to mortgage. So, ancora? Okay. So, the convention was needed for these two reasons: to have trust recognized and to have in a state which belongs to non-trust system, civil law system, and also because interests of private should have the possibility to be expressed in through trust. It's a new instrument for the private, for privates. And but the convention, we must say that it's not really a harmonization of law on trust. It's just a treaty about the conflict law. And so it enables people, private persons, to create trust, applying the law of a trust states. So states who recognize trust, who has a legislation on trust. And the problem is when and is going to face this convention with the situation which are transnational. The problem is when you have interest in a civil law state and they are internal to civil law state. I mean, when the settlor is an Italian one, the trustee is an Italian one and has his residence in Italy, when the assets are in Italy. So what happens in this case? Can persons create a trust and subject it to a law, a state knowing trust, or is it not possible? We have a specific rule in the convention, which is Article 13, and this article says as follows: It says that you have to, it's not possible, the judge can decide if recognize a trust which is not an international trust. I mean, a trust whose residence of settler or trustee and assets are internal to Italian state. So now the interpretation of this rule has been changed in the sense that this provision allow the states not to recognize internal trust, but does not prohibit. And so with this provision, our law changed completely their interpretation and decided to admit internal trusts. And it was possible for a series of reasons, and because the complex of the legal system, all the legal system, Italian legal system, has been changed from 89 till now, because I have listed a series of laws which are not explicitly on trust. Some of them are about the possibility to create single-member private limited liability companies, and this is a directive, European directive. Or another, it's about we call multiproprietà. It's relating to the purchase of the right to use immovable property on a timeshare basis. This legislation changed the concept of law of our legal system. The previous one changed the possibility for person to separate some of their assets for economic reason. Or also directive about personal data. Also that about this, the doctrine is discussing if this is a property right or not. So so many things changed the concept of property, the concept of separate fund. And also it was approved on 2006. See, yes, of course, I'm near to. A very important rule, which is Article 2645 ter, and it doesn't, it is not on trust, but it's quite trust. It's a general provision. So, what is the conclusion? The current issue is that trust is still missing in the Italian legal system. Lawyers and public notaries have a key role. They have to advise the settler. And they should have a knowledge of the context of the law that will govern the trust. The problems remain whether it is possible to create an internal trust without any reference to the law of a trust state. Some conclusion. Globalization is going to change deeply our life also as a lawyer. It's impossible to remain anchored to traditional categories. Property becomes properties. Separate funds become separate funds, and so on. Civil law systems are going to look like common law system because rules come from interpretation. And I think that all these things have to be faced on by young lawyer as you are. And I finish my this speech remembering Aristotle, who said, also when the laws are written, they should not remain unchanged. Thank you.
Thank you, Professor Levy, for this speech on this very interesting subject. So now I leave time for questions, if there are. Yes, please.
So you said that you do not form a national trust in Italy, but if in the fiduciary contract that de facto represents a national trust, are the assets considered allocated to the beneficiary or the settler or anyone else? Is there laws governing whose assets they are?
When you create a trust, the assets belongs to a separate fund, but it is not a subject. So you go to register the trust in a public register, but in the name of the trust, with the name of a trust in Italy. And you have also to specify the name of the trustee, which are the formal owner, and also of the beneficiaries, which are the real, the people who are going to become the owner at the end of trust. This is our system. Yeah. No, I mean, no. I told that we don't have a law regulating the trust, so we can do trust, but we have to apply till now a law of a trust state. So this is, I think, a very strange situation, because you have an advisor that should know very well the law of the country. Yes, of course, it could be. It could be. Yes, of course, it could be. But in any case, you can imagine how much should be, how much it is delicate, the role of the council in this case. You have to know also the law, or in any case, you have to get in touch with other council belonging to the different state. Okay.
I really want to thank you, Professor Levy, for this deep analysis of trust. And I have also some questions. Maybe I do only one question because the time is going fast. So, yeah. So I would like to ask to you if do you know if there is some specific organic draft legislation in Italy? They are discussing about
yes, I realize. Yes, there is a proposal of law about trust, and trust has been envisaged as a contract and should be inserted into Italian civil code after mandatory, but is still just a proposal. And in this situation, trust is seen as a contract, a relationship. So the matter of property is a secondary one. It's a contract. Trust is a contract. In any case, it's a contract who creates a separation between our concept who is a whole of ownership.
Just another question. Do you think we need a specific law, an organic specific law, or we can solve the problem with the jurisprudence, for example?
Oh, okay.
I don't know.
I think that a law should be a good solution if it is a good law, first of all. And unfortunately, at the present, we have laws which are not so good. Otherwise, we can manage. I think that we have already some general principle about trust in our system, and so we can use the will of the people, the person, and creating a trust, and also general principle which we have in our system. And some of them are related to some institutions which are very similar to trust. So we can use them. So it could be a solution without law. Law could clarify better, but should be a very good law. So
Thank you very much.
thank you to you too.
Do you want to another question? To review another question?
Any question for the public?
Yes, we have in our system. Yes, I listed. It was. We have so few time to discuss, but I put in the slide an indication about taxation. There is a specific indication in a law relating to income to trust, how they are taxed. Okay? Okay, thank you.
Now please welcome our next lecturer, Avvocato Davide San Giorgio, from the law firm Lunghini San Giorgio in Milan. Davide San Giorgio is founding partner at the law firm Lunghini San Giorgio in Milan, which is one of the law firms sponsoring this event today. He specialized in white-collar crimes, and he is university lecturer at the Master of Business Law at University of Milan Cattolica and of the Scuola di Specializzazione of Università degli Studi di Brescia. In his lecture today, he will focus on the Italian dual-track system consisting of criminal and administrative sanctions for market abuse offenses in the light of recent decisions of the Court of Justice. Thank you.
Thank you. Good morning, everybody. First of all, let me thank you, the coordinator panel of this event, and particularly Giulia Guagliardi of the European Young Bar Association, who honored me with the invitation today. During my speech, I will focus on the issue of the potential violation of the so-called ne bis in idem principle, means the general principle of a prohibition to be criminally judged twice for the same fact. This principle with regard to the national regulation which provide a system of so-called double jeopardy, means a system where both administrative and criminal sanctions are provided for the same offense, like the Italian legislation provision against market abuse. In fact, according to our national provisions provided in the so-called Italian Financial Act, which is provided in Legislative Decree number 58 issued in 1998, which regulate the financial markets and its player. Market abuse, which is both declined in the abuse of privileged information, the so-called insider trading, and market manipulation, is seriously punished both with an administrative sanction and with the criminal sanctions. This is why, therefore, we call and we speak about, with reference to our national system, of a double jeopardy system. The same fact of market abuse is punished both with as a criminal offense and as an administrative one. So the question, with reference to the general principle of ne bis in idem, is if the national regulation is in accordance with the provision, the general provision, set in two main supranational regulation. The first of all is provided in Article 4, Protocol 7 of the European Convention of Human Rights, which settled that no one shall be tried or punished again in a criminal proceeding under the jurisdiction of the same state for an offense for which he has been already finally acquitted or convicted in accordance with the law and penal procedure of that state. And the same principle is expressed also in Article 50 of the Charter of the Fundamental Rights of the European Union. So the answer to the issue is not obvious at all. In fact, there is a various set of case law, both of the European Court of Human Rights, of the Court of Justice, as well as from our national courts, the Constitutional Court and the Supreme Court of Cassazione, where we are here today. And also in respect of a recently amended provision, particularly referred to the which regulates the relation among the administrative side of the sanction and the criminal side of the sanction, referred to market abuse. Let's start from the set of decision of the European Court of Human Rights, and I will be obviously particularly cautious against any misrepresentation or lack of precision, being honored to have here today in the panel of the speakers the eminent former president of this court, Mr. Guido Raimondi. So the starting point from our view on the main decision is a well-known decision referred to a case named Grande Steven versus Italy, which was issued in 2014. The fact at the base of this decision is, first of all, a contestation coming from CONSOB, which is the Italian administrative authority for capital market and stock exchange in Italy. And this authority contested to the executive of a well-known company in Italy the administrative offense of market manipulation for having disclosed to market a false press release related to a company transaction. As a result of this administrative procedure, CONSOB imposed a heavy administrative pecuniary fine, and this sanction became definitive after appeal. Meanwhile, the same fact had been sent to trial before the criminal court in Torino with a charge provided in Article 185, which is a criminal provision for the same contested false press release, and so for an hypothesis of market abuse. So the defendant appealed in front of the European Court with reference to the Italian provision and the fact that on the base of the defense there was a supposed violation of Article 4, Protocol 7 that we have mentioned before. Means the principle who express the general provision of the ne bis in idem principle. So, in this decision, the court, the European Court of Human Rights, decided that there was, in fact, a violation in the regulation provided in the Italian Financial Market Act, on the basis of the fact that the administrative sanction which was issued against the defendant was, in fact, a substantially criminal sanction because of the heavy pecuniary sanction imposed that has to be considered at all effects as a criminal penalty rather than an administrative one, given their repressive nature, the relevant severity of the same, as well as the personal repercussion that came from this sanction. So this was a previous very relevant decision of the Court of the Human Rights. However, this clear judgment was then reviewed by a subsequent decision of the Great Chamber of the European Court of Human Rights, a judgment called A and B against Norway, which was issued in November 2016 in a tax-related offense also involving both an administrative side of sanction and a criminal side of sanction. We can speak of a real overturn in the interpretation of the European Court of Human Rights, because in this case the court has decided that the system of double jeopardy provided in the national regulation is not in violation of the nebis in idem under certain criteria. The general criteria is that among the two procedures there has to be a sufficiently close connection in substance and in time. And how this connection is expressed? It is expressed, let's say, about four main criteria. The first of all is the fact that the two proceedings, the administrative one and the criminal on the other side, has to have different purposes and to consider different profiles of the same antisocial conduct. Then the court considered relevant the criteria of the predictability of the double jeopardy, which can be known before the fact is committed, and which is, let's say, the most relevant criteria also following the following decision from the court, is the overall proportion of the two sentences, one referred to the administrative side and the other to the criminal side. So it has to be considered if the addition of these two sanctions is overall proportional. And then, as a matter of connection, is also relevant the chronological connection between the two proceedings. So this is a very relevant outcome after the decision of the Great Chamber of the European Court of Human Rights, coming from the named decision in 2016. And the relevance of this decision is also because it is, let's say, he exposed the criteria that are since that time reflected also in the following decision taken by different authorities. First of all, the Court of Justice of the European Union, which faced also the problem of the respect of the general criteria that we have read considering Article 50, with reference to a judgment named Garson Real Estate versus Consob, also referred to a market manipulation case. And this decision was settled in March 2018, and also this decision by the Court of Justice of the European Union mentioned the same criteria of the overall proportionality of the total penalty imposed from one side in the administrative proceeding and on the other side in the criminal proceeding. If this overall proportion is respected, then also the national system providing the double jeopardy is compliant with the general principle of ne bis in idem. And the relevance of this criteria, set for the first time by the European Court of Human Rights, was also reflected in a following decision taken by the Italian Constitutional Court with reference to an article 649 of the Procedural Criminal Code, the Italian Procedural Criminal Code, which also express a prohibition to a double criminal judgment on the same fact when a first one is settled and definitive. So the question was raised in front of the Italian Constitutional Court to evaluate if, in order with the ne bis in idem principle, there was a violation in the moment in which this article, 649, make reference only to a double criminal judgment and not also to a criminal and administrative judgment when the administrative judgment has a substantial imposition of a criminal penalty. But also the Italian Constitutional Court make reference to the criteria settled before the European courts, and so evaluated the fact that there was no violation of the ne bis in idem when a sufficiently close connection in substance in time were between the two different proceedings. And then I would like also to mention you a very recent decision by the Supreme Court of Cassazione, where we are hosted here today, settled in July 2018 in the so-called Franconi case, also a case of market abuse. And in this decision, the Supreme Court of Cassazione make explicit reference to the principle expressed by the European courts. It must therefore be conclusively affirmed that there is no violation of the ne bis in idem principle in the event that the penal and administrative sanction imposed as a whole respect the principle of proportionality in the light of the recent jurisprudence of the Court of Justice of the European Union and the European Court of Human Rights, mentioning exactly the decision that I mentioned and described before. So let's say this is a general overview of the main relevant decision of the courts, of the European and of the national courts with reference to the ne bis in idem, with reference to our national legal system regulating the capital markets against abuses and manipulation. But then we have also to consider that there was an also recent amendment to the provision in the Italian Financial Act that I mentioned as the act, the law in which is contained all the regulation referred to capital markets. And was an important amendment referred to Article 187 terdecies, which is particularly referred to the rules of coordination between the criminal sanction and the administrative sanction. This amended formula of Article 187 terdecies entered in force in September 2018. And I want to focus your attention on the provision under A, which reads, when the same fact, a pecuniary administrative sanction pursuant to Article 187 septies, or a criminal sanction, or an administrative sanction deriving from a crime has been applied to the offender, the author of the violation or of the entity, the judicial authority or concept takes into account at the time of imposing the sanction of its own competence the punitive measures already imposed. So this new formula refers to the judicial authority or to the administrative authority as concept to take into account in the moment in which they impose a following sanction on the same fact, which was already sanctioned previously by another alternative authority, to take into account what was the measure already imposed before to the same defendant for the same act. But then, let's say that it remains quite difficult for the interpreter to say what it means, taking into account, given the wide interpretation of this formula. And I would like to mention at your attention a very recent decision issued by the Criminal Court of Milano in first degree, third section of the Criminal Court of Milano, immediately after September 2018, so immediately after the entering in force of the new Article 187 terdecies. And the reasoning of this decision was released on February 2019. The important rule that has been applied, also exactly applying the rule of taking into account, is that in this case, a previous administrative sanction was already imposed against the defendant. So in this case, the criminal proceeding arrived after the first, which was an administrative proceeding. And in this case, the criminal judge, taking into account, decided that the criminal sanction has to be reduced even beyond the minimum provision for this criminal offense. In fact, in this act, taking into account what was already imposed to the defendants as a pecuniary sanction, this produced a reduction in the criminal penalty which was emitted against the same defendant, even beyond of 1 year and 4 months of detention, even beyond the minimum provision for this criminal offense, which is set in 2 years. So the important rules which was set in this decision of the Court of Milano is the fact that given the new formula of Article 187 terdecies, the possibility to take in account a previous penalty imposed in the administrative side can also produce an effect on different kind of sanction, as it is custody and detention provided on the criminal side, till the possibility to disapply completely or only partially the sanction applicable at the end of this second and criminal trial. And this appears a very relevant decision because it is, in fact, let's say, the first application and interpretation of the criteria of taking in account, which is now provided to regulate the relation among the administrative side and of the criminal side of the double jeopardy system against market abuse. But then I would like also to mention a really recent decision of the European Court of Human Rights. So we come back to the European scenario, which was issued just 50 days ago, on 6th of June 2019, in the case Naudet versus France. The case under the decision was referred to the provision in the French regulation system against market abuse, which was in force before 2016. In France, in 2016, there has been a modification in the general set of regulation referred to market abuse. But this case was referred to the previous set of regulation of capital markets, which has the current Italian system, a system in which it is provided double jeopardy for the same fact. And I think it is important to mention this very last decision of the European Court of Human Rights, because it seems to me that it added some very relevant point of evaluation to the general criteria of overall proportion, which was, let's say, reached as the main criteria of evaluation, as we have described. Because the court made a step beyond this criteria, considering the fact that it is not always sufficient to make reference to the overall proportion of the punitive response. And it comes back to the other criteria also expressed in the AMB versus Norway case in 2016, because it goes back to the fact that there shall be a connection, but this connection is expressed also in the different purposes of the two proceedings. While, on the contrary, in this decision, very recent of the European Court, it is recognized the fact that in the rules of the financial French market at time, there was a theological uniqueness of the two proceedings, the administrative and the criminal one. And so this has to be highly considered, because open the side to a possible violation of the ne bis in idem criteria. So, in conclusion of my speech, I think that was important to mention the full scenario of the decision, and with particular reference to this very last decision of the European Court of Human Rights, because it seems to me that the double jeopardy provided for in Italy by the Italian Financial Act, as it was the one in France considered by this last decision of the European Court, it still appears to be exposed to significant compliance under Article 4 of the Protocol 7 of the European Convention of Human Rights for a possible violation of the ne bis in idem principle. I thank you for your kind attention.
Thank you, Davide, for your intervention, which allows us to introduce also our next speaker. But first, I would like to ask if there are some questions. Of course, please.
Yeah, you make a correct point. Consider the fact that the general criteria of ne bis in idem is expressed both if the first decision is an acquittal decision or a conviction decision. Means it is expressed as a second judgment for the same fact, not considering if the first decision was an acquittal decision or a conviction decision. So the general principle is expressed not considering relevant is if the first decision was an acquittal one or a conviction one. So it's expressed as the prohibition to impose a second proceeding for the same fact against the same person. But then, as you correctly pointed, the Italian provision, which was recently amended, make reference only to, let's say, a little, regulates just directly just the case of a previous conviction, mentioning the taking in account in imposing a penalty and making reference to a previous penalty imposed. So, as you will well notice, this particular national rule doesn't solve the entire reference to the general criteria of ne bis in idem. Is a partial solution referred to trying to express a formula of evaluation only referred to the case of a double conviction. So only in the case in which the double judgment coming, no matter if the second is administrative or criminal, is doubling a previous conviction sanction.
Any other question from the public? Please, and then on the...
It has, your colleague is making reference to the general provision who consider liable also the entity in which a representative, an individual representative has committed a crime of market abuse. This means, with reference to Decree 231, 2001, also a responsibility against the entity which was, for which in their interest and advantage with the crime was committed by the individual. And as you will see, the formula amended make reference both to the sanction emitted to the author of the violation or the entity. So there is a clear reference also to the applicability of this new formula also to the sanction emitted against the entity.
There is another question from upstairs. Okay.
Yeah. Yeah. No, I get the point. I hope to have get the point. So, your question consent me to also to put in clear another argument, which is the fact that there is a very particular, making reference to the presumption of innocence and the way in which in Italy the administrative proceeding and the criminal proceeding has relation with reference also to the evidences gathered in one of the two that reflects to the other. Because you have to consider a very relevant and I would say particular scenario, which is in Italy, that you have to consider that CONSOB, which is the administrative authority in Italy for the capital markets, is the entity, the administrative entity, which in the first degree emit the administrative sanction and investigate in the administrative side of the matter, then to decide if a sanction has to be imposed only on the administrative side. But then CONSOB is also part of the criminal proceeding because CONSOB has an authority, has an obligation to send also a notice of crime to the office of the power prosecutor. So many times, I will say almost every time, CONSOB is the first authority who may start the criminal proceeding because of the notice of crime that is sent to the power prosecutor office, and then can also take part of this proceeding as damaged part during the criminal proceeding. So there is obviously a strong argument which has to be considered with reference to the fact that also evidences gathered in the side of the administrative proceeding without any defensive guarantee can be then gathered, put also through the hands of CONSOB in the criminal proceeding. Imagine the fact that if you are an individual in front of CONSOB and you are called by CONSOB, then you have an obligation to present yourself, and you can commit a crime if you don't reply to the request of the information coming from CONSOB. But then during this investigation gathered by CONSOB, you have the right of defense. There is a lawyer with you. You have not the right to be assisted by a lawyer. So your information, your declaration can be gathered in front of CONSOB and then can be used with some limits, but let's say are generally used also on the criminal side of the matter. So I think you pointed a very relevant point, and I don't know if I replied your question. Yeah, there is a general rule on the criminal side for which they cannot be used the declaration that you rendered in the moment in which you were just a witness, if you then assume the different role of defendant. But No, means I want to describe which are the possible, beside the provision referred to the sanction. I want to mention at your attention also the relation among how evidences are collected and how a flow of evidence can pass from the administrative side to the criminal side, which I think is relevant. Also because, and this is, I think, a very peculiar for the Italian regulation, you have to consider that is the same administrative authority who make the investigation, and then the same authority who emit the administrative sanction, which is different, for instance, for what happens in the UK.
Okay, thank you very much. So, Mr. San Giorgio, of course.
That is very controversial, this point. It's just to try to focus in the most simple way, let's say, also. Okay. Thank you.
Thank you very much to Mr. San Giorgio. So, may we take applause? So, even if there is no need of any presentation, I have the honor to introduce the final speech of President Guido Raimondi, past President of the European Court of Human Rights. He is a very well-known judge here in Italy because he is here in the Supreme Court of Rome, in the labor section. And of course, so I leave you all the scene and the word.
Well, thank you very much. No, it's a great opportunity for me. I'm really grateful to the organizers for inviting me. It's a great opportunity to address young lawyers, and so in order to try to raise some awareness of the European system of for the protection of human rights, and possibly some interest, which is really crucial, because the role of the lawyer is fundamental in the framework of the European system for the protection of human rights. So the awareness of lawyers, especially young lawyers, is absolutely of essence. So this is a great opportunity. So with the organizers, we decided that I will try to offer to you a general presentation about the European Convention on Human Rights and the European Court of Human Rights. And I understand I have been granted 20 minutes roughly for that. So I will try to address four points, which are relatively big points. So 20 minutes, it's maybe too short a time, but I'll try to do my best. So the 4 points are the following. First, the origins of the system. So some history, why the system was created, which were the political conditions of the time when the system was created, and so on and so forth. Second point, the structure of the system and its functioning, and also seen in its historical perspective, because we can see definitely an evolution of the system since its very beginning in 1950. This date is known to most of you, I understand. 1950 is when the Convention on Human Rights, the European Convention on Human Rights, was signed in Rome in November 1950. And then the system knew a certain evolution. Third point, the main features of the case law. The case law is immense. Of course, it's not possible to address it in 20 minutes, but I'll try to provide you with some elements on the main pillars of the jurisprudence of the court. And fourth point, the current trends and the current perspectives of the system. So it's an ambitious program, I understand, and I recognize. But so the origins. So I already mentioned 1950, which is of course a very important date because it's the date of the signature, the adoption and the signature of the convention here in Rome. And so the convention was as such a revolution in the panorama of the international law of the time. So the system, which is based on the fact, on the idea that an individual can bring an action before an international institution in order to check whether a sovereign state has violated one of the rights which are enshrined in this very peculiar catalogue of rights, which is the European Convention of Human Rights. This was absolutely revolutionary. In the idea, the concept of international law, even before World War II, this was simply inconceivable because at the time, individuals were relevant in international law only if they were foreigner. But the power of the sovereign state vis-à-vis its own citizens was considered absolutely out of question and without any limitations. In the 30s, we had an outstanding professor of international law, who was Rolando Quadri, and he published a monography on international law in 1936, which was La sudditanza in diritto internazionale, so the subjects in international law. And he could say, and he was probably right at the time, that the relationship, the legal relationship between the sovereign state and its own nationals was comparable to the relationship existing between the owner and the thing which is owned by the owner. So it was a relationship of private law. No interference was conceivable when it came to the relationship between the sovereign state and its own citizen. This changed dramatically after World War II, and this is it was really a revolutionary idea that now states are responsible also for the way they treat their own citizens if they trespass certain boundaries when it comes to the respect of their fundamental rights. This was the idea. The idea was enshrined already in a very famous and solemn document, which was the Universal Declaration of Human Rights, adopted by the General Assembly of the United Nations in December 1948. But that document, as you know, has not binding force. So the European Convention, which was adopted 2 years later, was the first binding international document on the protection of human rights. So the particular history of that document is very much linked to the creation of the Council of Europe, which was one of the first European organizations created after the war. The Council of Europe was established in 1949, and so it was very quick process. Just in 1 year, the convention was negotiated and adopted in Rome in November 1950. So this was more or less this is the historical background, which is of course very much more, it's more complex than that, but I cannot really say more for the time being, but then we can come back even to that interesting part during the debate. Now, the structure and the functioning. I already mentioned there is a clear evolution of the system. The system was conceived in 1950 as the result of a compromise, and of a difficult compromise. States are not really normally willing to renounce important parts of their sovereignty, which was what happened with the adoption of the Convention, because states accepted to be controlled, so to speak, on their respect for the human rights enshrined in the Convention. At the time, so the compromise was that the Convention was full of optional clauses. And the very idea of the individual petition, individual complaint, which is the pillar of the system, so the very fact that power is granted to all of us, to individuals, not necessarily European individuals, so everybody who is confronted with the use of power by one of the contracting states has the right to check, to ask an international body, an independent international body, to check whether a particular state has respected its obligations. So this was at the beginning subject to an optional clause. And the structure of the system was based on three organs: a European Commission for the Protection of Human Rights, a European Court, and the Committee of Ministers. Committee of Ministers is the political body of the Council of Europe. At the beginning, so with the first shape of the system, the Committee of Ministers was also granted, which was a scandal, judicial powers. So we had three organs. The individual petition was conceived, it was optional, but it was conceived only vis-à-vis the Commission, which had not real full judicial powers, but only negative judicial powers. The Commission could declare a case inadmissible, but had not the right to adjudicate the case. Adjudication was either for the court, which cannot be seized directly by the individual, or by scandal by the Committee of Ministers. So this system was universally criticized, but had the merit to exist. So for the first time, the individual, even subject to an optional clause, was able to bring a case to Strasbourg. This changed dramatically in 1998 when Protocol 11 to the Convention entered into force, and Protocol 11 changed dramatically the system in the sense that the Committee of Ministers kept some important functions. They are still there. Committee of Ministers is responsible for monitoring the execution of the judgments of the court. But with 1998, the Committee of Ministers lost its judicial prerogatives. The two original bodies, Commission and Court, were merged. So now we have only one body, the Court, the European Court of Human Rights, which regroups the competences of the first, the old Commission, and of the old Court. And, which is the most important thing, now individuals may bring cases directly to the court, and the right of individual petition, of individual application, is no longer subject to an optional clause. So states ratifying the Convention are now obliged to accept the system of individual petition, of individual application. So now the court is made up of 47 judges. Why 47? Because, as I said before, the Convention is linked to the Council of Europe. Only states which are members of the Council of Europe can become contracting states to the Convention. And that there is one judge for each contracting party. Well, this is obvious, but this doesn't mean that judges represent their own state. This is obvious. Judges are independent and are supposed to sit having in mind only the idea of the good application of the Convention, with the duty, of course, not to receive instructions from their states. But states have a say in the election of judges, because judges are in fact elected. In the Council of Europe, there is also a parliamentary dimension. There is the Parliamentary Assembly of the Council of Europe, which is a parliament which is not elected directly by people. It is composed of delegations of national parliaments, and this Parliamentary Assembly has the duty and the right to elect judges. The election of judges is based on the presentation by the states of candidates. Each state presents 3 candidates, and then the Assembly elects 1. Now, of course, the things are more complicated than that, in the sense that the practice of the Assembly and the practice of the Committee of Ministers have introduced some details in this apparently extremely simple procedure. And in fact, now, before the state is allowed to present the list of 3 candidates to the Assembly, there is a prior screening made by an independent commission, which is the advisory panel for the election of judges, which is established by the Committee of Ministers, but which is absolutely independent. And this committee, you have some resemblance with the 255 committee, which exists in the framework of the European Union. You may be familiar with that committee, but the big difference is that this panel has not binding powers. It has only the power to exert some moral suasion. So in case there is a one or more candidates who do not fulfill the criteria established by the Convention, then the committee panel has the right to address to approach the concerned government and try to convince this government to change the list. Well, I don't go into further details when it comes to the election of judges, but of course, election of judges is a key issue, is a crucial issue, because the credibility of the court, the quality of the court depends on the quality of its judges. This is also obvious. So the court, the structure of the court, for the 47 judges meet together sometimes. This is the plenary assembly of the court, but the plenary has no judicial functions. The most important judicial panel of the court is the Grand Chamber, already mentioned by Mr. San Giorgio, and which is made up of 17 judges, and which is the most solemn formation. The normal, so to speak, formation of the court is the chamber, which is made up of 7 judges. Most cases, I would say, most relevant cases of the court are adjudicated by the chambers. Then there is the committee of 3 judges. The 3 judges have the right to declare cases inadmissible, but since 2010, when Protocol 14 entered into force, they have also another important task. They can adjudicate in a definitive way cases on which there is what we called in the jargon of the court WECL, so well-established case law. So cases which basically are of a repetitive nature can be adjudicated definitely by this committee of 3 judges, which means relatively quickly. And an important feature of the committee of 3 judges is that the presence of the so-called national judge is not required. Since that for the other two big formations, chamber and the grand chamber, the participation of the judge elected in respect of the concerned state is mandatory. This is not the case in committees. And there is also a smaller formation, which is the single judge, which was inaugurated, so to speak, when Protocol 14 entered into force again in June 2010. And the single judge has only a negative power. The single judge can only declare cases inadmissible. So this is how the court works. Of course, there are articulations among these different formations, but of course we cannot enter into details now, because I want to speak about the case law. But then we can, if there is interest, we can of course address these particularities, these specificities, these details during the debate. Now the case law, maybe the most interesting. Have I still 10 minutes? Well, no, the case law is immense, and there are more than 20,000 judgments adopted by the court. So it's safe to say that nobody knows the case law of the court. So when you approach a case in the Strasbourg system, so to speak, of course, you have to be modest. You have to start from scratch. You have to check and to read as many judgments as possible, to have a clear idea of the jurisprudence on that particular issue, because the issues are really many. There are the convention covers all the aspects of social life. So there is family law, there is administrative law, criminal law, international law, migration, so bioethical problems, everything is covered by the convention. So this is why the corpus of case law is so vast. So I cannot address, of course, the jurisprudence as such, but I can tell you something on the main features, in the sense that there are some judgments which are particularly important because they establish, so to speak, the pillars of the case law, so the basic principles on which the whole building is built, so to speak. And I would mention maybe 5 or 6 judgments which are relevant in this connection. The first one is Golda. This is the very basic one, in the sense that Golda is a judgment in a case concerning the United Kingdom. Most of these important cases concern United Kingdom, and this case is important in many regards. This is the famous case where the court said that the right of access to court, even if it is not mentioned by Article 6, it is implicitly included in Article 6. But how the court reached that major achievement? Because in that judgment, the court established the criteria for the interpretation of the convention. So you can imagine this is really a very important issue. And the court said the convention is an international treaty. So there are rules on interpretation of treaties established at international level. So there is customary international law on interpretation of treaties. And the court referred even to the Vienna Convention of 1965 on the law of treaties, which is, as you know, a universal convention adopted by the UN, and which might look like a paradox, because we know that treaties are not retroactive, and the convention is of 1950, how can a treaty adopted in 1969 be used to interpret the convention adopted in 1950? But of course the explanation is obvious and even trivial in the sense that the Vienna Convention is a codification convention. So the Vienna Convention codifies customary international law. You know, codification conventions not only do not contain only law which already exists. There is also a development of international law in codification convention. But the relevant stipulations of the Vienna Convention, namely Articles 31 to 33, refer to what was already established customary international law in 1950 when the convention was adopted. And what is the most important thing? Most important thing is that the objective criteria of interpretation and not the subjective criteria of interpretation has to be followed. This means that les travaux préparatoires have only a relative importance. What is important is the real text of the instrument, and what is important is to interpret the text in light of the object and purpose of the text. And this is really a major achievement, because had the court followed the principle of subjective interpretation, then nothing would have happened, very likely. So all this immense corpus of case law simply would not have been developed. So, and as a follow-up to this, I would cite another important point established by jurisprudence, which is very much linked with the presentation, with the remarkable presentation we received by Mr. San Giorgio, namely the doctrine of autonomous interpretation, which means that expressions which are enshrined in the convention, unless this is specified in the same convention, are not to be interpreted according to the criteria of the law of the concerned state, but on the contrary, they have to be interpreted in an autonomous way. And this we already heard on nebis in idem issues. Everything starts from the fact that the idea, the concept of criminal sanction is not to be established according to the law of the concerned state, but it is an autonomous European concept. And this is why sanctions which are qualified as administrative in national law can be, according to the Engel criteria mentioned by Mr. San Giorgio, qualified as criminal sanctions in European law, which means that this triggers all the guarantees established by the conventional law for criminal sanctions. Presumption of innocence, ne bis in idem, this is in the Protocol 7, principle of legality, nullum crimen, nulla pena sine lege, and so on and so forth. So this is also a very important achievement of the case law, which is normally referred to the case of Engels versus the Netherlands. In the same vein, I would also mention a third judgment which is important, which is Tyler versus the UK. Why Tyler is important? Because Tyler fixes the doctrine of the evolutive interpretation or the doctrine which is also called the living instrument. This means that the convention has not to be interpreted in, so to speak, an originalist way. You know the originalism of the American constitutionalism, and in particular the position, for instance, of Judge Scalia was really a champion of originalism. Originalism means that the text should be interpreted according to the social, historical, economic situation of the moment when the text was adopted. So, if this doctrine was followed by the court should have interpreted the convention according to the criteria of 1950. But this has not been the case. In Tyrer was an Article 3 case. Article 3 prohibits torture and other treatment or punishments which are degrading or inhuman. And this concerned corporal punishment in the Isle of Man in the United Kingdom, which had a very special regime. And so the obvious consideration was, but of course, this was very well known. This existed in 1950. So if the British delegation at the time decided to accept this text, this was because it was clear that that kind of punishment was covered, was permitted by Article 3. Otherwise, the UK would have never accepted this kind of text. But then the court replied, no, this is not the case because the convention is a living instrument. It has to be interpreted in accordance with the evolution of society, so in all its parts, so economy, science, and so on and so forth. And this is why now there are some areas which were absolutely, certainly not considered at all by those who adopted the convention in 1950, protection of homosexuals, protection of environment, which are now, in fact, under the protection of the convention due to this doctrine. So this is Tyrer. Another important judgment is Andesite. Andesite is important from maybe another point of view, because so far the three judgments I mentioned go in the sense of widening, so to speak, the sphere of the applicant, of the individual. Andesite is remembered more because it's not created, that did not create because it was done before, but provided a clear framework for the doctrine, which is also important, of the margin of appreciation. Are you familiar with this doctrine of margin of appreciation? This means that the court is relatively deferent vis-à-vis solutions adopted for the protection of human rights at national level. And this includes both the legislator and the judge. The idea is the local authorities, the national authorities are closer to the situation which needs to be regulated, so they are in principle in a better position than the court to address that situation. And this also implies that there is not a single way of protecting human rights. This means that national differences are conceivable and even allowed to a certain extent by the court. And in fact, you know, with the 47 member states, this goes well beyond the European Union. There are differences which are quite relevant, and the court should respect these differences to a certain extent, because there is, at the end of the day, an hard core of principles which should be the same all over the 47 states. And when these principles, this hardcore part of the principles are at stake, then the court has to intervene and to put in place what is called, in this Andesite judgment, European control. So the court has to intervene. Well, I have to be extremely quick and apologize for being so simplistic. But I want to give you an idea of the most important pillars of the case law, because I have still two things to mention. One is Söring, and the other one is Array versus Ireland. The first judgment, Söring, is important because it introduces the dimension of the indirect application of the Convention. So the Convention applies, of course, normally in the territory of contracting states, which is obvious. But it has some extra-territorial application, so to speak, or indirect application when it comes to situations where a person is in the jurisdiction of a contracting state, but this state wants to get rid, so to speak, of this person. So wants either to deportate this person or to extradite this person to a third country. So this principle established by the Söring jurisprudence, which dates back to 89, it's again a case against UK and Germany, and the idea is that a contracting state is not free to expose a person who is within its jurisdiction to treatments which can be contrary to the Convention, treatments which could take place not in a contracting state but elsewhere. So this is an indirect application of the Convention. And this doesn't mean that the whole Convention works indirectly. So not every single right protected by the Convention works in this connection, but only the core part of the Convention. So basic rights, Article 2, Article 3. Article 3 I already mentioned. Article 2 is right to life. So if a person is exposed to dangers to his or her life, or exposed to torture or the inhuman degrading treatments, then the state has the duty under the Convention not to expose that person. Now, there have been some widening also of this concept of the core part of the Convention, in the sense that Article 6 has also been used in this connection, which is extremely interesting. But Article 6, as most of you know, is the article of the Convention which deals with fair trial. So there are the guarantees of a fair trial. Now, not all the guarantees of the fair trial work indirectly in the Söring perspective, but the core part of Article 6 works, in the sense that, for instance, in a case which suscitated a lot of emotion in the UK, which is Othman or Abu Qatada versus the UK, the question was that a person was requested, who was in the UK, was requested in extradition by Jordan, and the risk was not the risk of torture for him, but the risk was that in his trial in Jordan, evidence obtained with torture could be used against him. And this was the reason why the court said, if extradition is put in place under these conditions, there is a potential violation of the Convention. So an indirect application of Article 6. This is also a perspective of some interest. And last point I want to address from the point of view of the case law is the protection of social rights. And this is why I mentioned the case of Eyre versus Ireland, a famous case of 1979. This case, because the Convention is basically a classical human rights instrument which is devoted essentially to what we call normally first generation rights, so civil and political rights. In principle, the Convention doesn't deal with what we call second generation rights, i.e. social and economic rights. So, in principle, yes, these rights are not covered. But the court has developed a certain case law, we would say in Italian Pretoria, case law, which gives some significance even to social and economic rights. So this was revealed exactly with this case of Ere versus Ireland of 1979. Because what happened? It was the question of a right to access to justice, the right I mentioned before, which was for the first time affirmed in Golda, which is implicitly included in Article 6. It was an Irish lady who had to start the proceedings of the divorce, and she did not fulfill the criteria for legal aid, so she couldn't hire a lawyer. And she said, well, Ireland is responsible because if I have the right to access the judge, but have no means to hire a lawyer, so this is a breach. The reply of the Irish government was, well, but this is not my problem, because this is not the fact that you are not in a position to pay a lawyer is a question of social rights. This is not covered by the convention. The convention is intended to protect only civil and political rights, so this is simply incompatible ratione materia with the convention. But the reply of the court was no. There is no, and this is the famous sentence, no cloison étanche, no watertight division, separation, no watertight separation between social and economic rights on one hand and civil and political rights on the other hand. If a certain action, positive action, is required by the state in order to allow persons to benefit of the social, of the political, civil and political rights enshrined in the convention, then this action is required by the convention. So the court found a breach. And this is a jurisprudence which creates some protection for social rights as extensions of civil and political rights. But the court went even further than that and developed some case law in order to afford some protection to economic and social rights. First of all, the court developed some autonomous meaning of Article 14. This is maybe I'm speaking in a cryptic way, but for those who are not specialists of the convention, Article 14 is the provision which prohibits discrimination, but it is not a general one. So Article 14 does not prohibit discrimination in a general way across the board, but it functions only with regard to rights already protected by the convention. But the court developed a certain autonomous meaning of the anti-discrimination clause, which is enshrined in Article 14, because it said, if there is a measure, normally a social benefit, a measure which is autonomously decided by a state and for which the state is not obliged by the convention, but this measure falls generally within the ambit of one of the articles of the convention, then the state has the obligation under Article 14 in order to provide this measure, this benefit, in a way which is not discriminatory. So the jurisprudence of the court on discrimination applies. The classical example are benefits for the family which are not imposed by the convention but fall within the ambit of Article 8 of the convention, which protects private and family life. So in that case, the court could, for instance, say, if you established a social benefit concerning family, you cannot do that only for nationals. But if you distinguish between national and foreigners, you have to explain why, and to provide a suitable explanation which can maybe be a justification, because not all differences of treatment are discrimination. Only unjustified differences of treatment are discrimination. So but the court provided a protection from this point of view. And last point on social and economic rights, the court has exploited, so to speak, one of the most liberal provisions which in the system, which is Article 1 of Protocol 1, which protects property. Because now property, of course, is the least social, maybe, right, which can be found in the Convention. But the court developed also the concept of property in order to include all possessions. Possessions are credits. If there is a social benefit which is established by law, this is a benefit, irrespective of the question whether the benefit is contributory or not contributory, in the sense that it can be social security or simply social assistance. But if the benefit is clearly established by the law, then there is a right. This is a right of property, right of possession, which is protected by the Convention protocol. This doesn't mean that the state cannot intervene on this kind of benefits, of course, and the state did intervene, especially in the framework of this horrible crisis, which is not yet over. But the state can intervene, but it has to do that within the limits established by Protocol 1. This means that the state needs a legal basis, needs a legitimate purpose, and needs proportionality. So it needs to intervene to the extent required by the circumstances and not more. This the court said in a famous case, which is Steck versus the United Kingdom. This is a very important case from in this regard. Of course, illusions should not be there. The court cannot do much in especially when there is a severe economic crisis, because the margin of appreciation applies. The court is normally differential vis-à-vis choices of economic policy made at national level, which is of course normal because the court has no, if not very slight, democratic legitimation. So these are choices for national parliaments, but in some instances, extreme instances, the court intervenes. For instance, it was a taxation imposed by Hungary in the NKM case, which went too far because it was a taxation going up to 98% of the benefit concern, which was the last payment of a worker. And so the court, no, that's too much, that you did not respect the principle of proportionality, so the court could intervene. But of course, the room of maneuver is not unlimited. Now I go to the last part of my speech, if I have still some minutes. Thank you. Just to speak about the current trends, what are the perspectives of the court, and this will, in a way, on va boucler la boucle. This will explain why this meeting of today is so important for me, for us, and because and why you are so crucial for the system. Because now the big problem of the court is the big backlog. There are too many cases, 57,000 roughly. This is a major improvement vis-à-vis the situation of some years ago, where we used to have 160,000 cases. Now, of course, there is we can evoke an improvement, but 57,000 are still too many. And this means that the court has real difficulties of functioning. The court is extremely able in getting rid, so to speak, of clearly inadmissible cases. The court receives roughly, on average, 60,000 cases per year. 95% of these cases are declared inadmissible by a single judge, so the court is very efficient in that, but this is not, cannot be a source of big satisfaction for applicants, of course. But the court is not that efficient when it comes to cases which are serious cases. And unfortunately, and this is a reality which cannot be and should not be concealed, the court can deliver even 8 years, 9 years, 10 years after an application is filed with the court, which is absolutely unsatisfactory. The court has adopted a policy of prioritization of applications, which means that cases which are considered urgent are treated relatively quickly. Relatively, which means 3 or 4 years. But cases which are not of a priority nature, and in this category, unfortunately, we have serious things like freedom of expression, for instance. This is not one of the priority issues, unless, of course, there are, of course, special decisions which can be taken in order to give a given case a fast track. This is always possible. But in principle, for freedom of expression is not a priority issue. So the problem is there. And what is the solution? Increasing of the resources of the court is not an option. This is especially in these times. So the real solution is to work on the subsidiary nature of the system. The system is subsidiary in the sense that you cannot address the Strasbourg court without prior exhaustion of national remedies. This is an old rule of international law, but this means that the national system should work properly. So why the court has so many applications? Because national systems, or at least some of them, don't work properly. In fact, of these 57,000 cases, more than 70%, 70%, belongs to or come from only 5 states. Unfortunately, Italy is among these 5 states, but now Italy is the 5th. It used to be the first one, so at least we are. And since I speak about my own country, I have to say that we could notice also dramatic improvement when it comes to Italy, because when I arrived at the court in 2010, Italy had 17,000 pending applications. Now they are less than 3,000, which means in any event. But this is just a parenthesis. Now yes, of course, absolutely. Absolutely. No, absolutely. No, I know. And I apologize for being too long. Yes, but I was already at the end. I want to say just one word on the EU, but I simply say that the idea is that the two systems should work together. And my final word would be on the subsidiary nature of the system. So let's have the convention live well at national level. This will preserve the national systems and preserve the European system. Thank you very much for your attention.
So I would like to thank you on behalf of the organizing committee and on behalf of the European Young Bar Association. Thank you for coming. I know it was very difficult. You were in Strasbourg yesterday, so thank you. It's an honor. So now we can have lunch outside, and then there is the annual general meeting. But if there are some questions, I'm not sure if you want to ask. Just, if you want, you can come here near the microphone. Okay, speak loud. Okay.
Thank you for taking my question. Well, you said that there are 5 countries who are involved in 70% of the cases. And I've noticed that some countries are all the time in front of the court for the same problems and being condemned by the court for the same issues, which leads me to believe that they do not want to comply with the rules set out by the court. Would the court have any means, or would you think that some evolution would need to be done to give the court the possibility to enforce its decisions, so to speak? And there's a second question, it's more global. What kind of evolutions would you like to see for the court? Thank you.
Thank you very much. There is serious risk of delaying lunch, but I apologize for that. No, but yes, you addressed several questions, because one is the question of repetitive applications, which of course is linked to the question of execution and implementation, because of course if there are repetitive applications, this means that there are difficulties in the execution of judgments, so the states don't comply. And there are two different issues linked, and both are extremely important. When it comes to the first one, repetitive application, of course there are several dimensions, but one of the dimensions is the way the court tackles with these issues. And from this point of view, it is true, out of the 57,000, roughly 25,000 cases are repetitive applications, but now the court has all the tools to deal efficiently with these cases. We are now close, I say we, I'm no longer in the court, but okay, the court is close to apply even artificial intelligence to these cases. Now it's not really difficult for the court to deal with these cases, so they do not require a major waste of resources. But of course the problem remains of execution. But when it comes to execution, I already mentioned that a key role is played by the Committee of Ministers, which is the political body of the Council of Europe. And in fact, the Committee of Ministers has this task of monitoring the execution. Execution is mandatory. You know, Article 46 of the Convention stipulates that judgments of the court are binding upon the parties. I don't enter the question what's the meaning for other states not being party, because this is another chapter we will not address today. But the concerned state is obliged to execute. But there are different types of difficulties in execution, because there are practical difficulties. Even if Italy is not an example, because we had this question of excessive length of proceedings, which has been noticed already 40 years ago by the court, and it is still there, not yet resolved. But one could not say that there is a political will of Italy not to implement that part of the case law. There are other more difficult cases where there is a political dimension. Maybe I can mention, because there are cases concerning several countries, but I will mention one case because there is an happy ending, which is the British case, which is very famous, the Hearst case, the Hearst judgment of 2005, in which the court said that the British system on disenfranchisement of prisoners, you mean that for the very fact that you are detained after following a sentence, you are not allowed to vote, for the simple fact. And the court said this is not compatible with the convention. It was in fact Article 3 of the additional protocol, which protects elections, because the court said, of course, you cannot limit the right to vote of prisoners, but you have to establish criteria. You have to link this to the severity of the crime committed. You cannot simply have a blanket ban. But this, created some emotion in the UK. There was also even a vote taken by the House of Commons with an overwhelming majority. So majority and opposition voted in the same way, just not to execute the judgment, because this was considered an undue interference of an European institution into domestic affairs. So this was a real problem for several years. The judgment was not executed, and this of course was a very bad example, because for other countries, of course all countries are equal, but of course the tradition of the UK when it comes to protection of human rights and of rule of law is not comparable to the traditions of other countries, and I'll stop that. But at the end of the day, this was resolved, not with the intervention of the Parliament,
but with an act of goodwill of the government, and in particular of the then Lord Chancellor Lidington, who he was Lord Chancellor in not in the current May government, in the previous May government, and he found this pragmatic solution, because he said, well, in fact, and due to the particularities of British law, prisoners cannot vote because they have not a residence, because you need to have a residence to vote. And he had within his powers the possibility to say that prisoners convicted up to 1 year could keep their residence. So he could say, well, this is not longer a blanket ban, because we allow prisoners who are convicted up to 1 year to vote. So this was realized. I don't know whether this will hold before the court. Maybe we'll have other applications. I don't know. But at the level of the Committee of Ministers, that was sufficient to say that the UK had implemented one happy ending. There are other cases where there is no happy ending. I can refer to Transnistrian cases. There are a group of cases concerning Transnistria. I don't know whether you are familiar with that particular region of Europe, which is a part of Moldova, which is not controlled by Moldova, and for which the court believes that there is responsibility of the Russian Federation for what happens there. And the Russian Federation doesn't accept this, so for political reasons these judgments are not executed. This is a more difficult issue. I understand that maybe we have no time, so I have to stop here, because there are a lot of other interesting things related to your questions.
Last word, I would like to express all my gratitude to a person who made this part possible, to Giulia Guagliardi, our President of the Italian Committee. The lunch is open.